two questions, both of which address the status of this rule as an emergency temporary standard. So my first question has to do with the question with which Justice Thomas opened, which is the meaning of necessary. So, of course, when OSHA passes a rule through its regular regulatory process, it has to go through notice and comment, and that's a way of holding an agency accountable. All affected people have an opportunity to comment, and the agency develops a robust record. With an ETS, of course, the agency can circumvent that process so that it can act more quickly. So for an ETS, we would want that power to be the exception, not the rule. And one contrast that the applicants point out between OSHA's authority to issue an ETS versus a regular regulation is that for its exercise of power in the normal course, it need only find that a regulation be reasonably necessary, but for an ETS, it has to satisfy a necessary standard. Now, you've argued, and I think there's a lot of intuitive appeal to this, that when you're facing an emergency of the magnitude of this pandemic, that this power effectively can be used most effectively as a blunt instrument. You know, we don't have time to make industry by industry specific kind of calculations because we want to move with speed. But how do you reconcile that understanding of necessary with the broader reasonably necessary standard in OSHA's normal regulatory authority?
So we certainly agree that the emergency temporary standards reference to necessary as contrasted with reasonably necessary and appropriate is a heightened burden and includes a measure of tailoring that's necessary with respect to the particular mitigation measures. But I don't think that that helps the applicants here because they haven't come forward with any alternative mitigation measures that they think would equally protect the workers that OSHA found were in grave danger.
But do they have to come forward with that evidence, or did OSHA have to consider it and reject it? Because another part of their contention is that OSHA did not adequately explain why this measure, this particular rule in its scope, was necessary vis-a-vis or as compared to other possibilities.
Well, OSHA explained that at length over dozens of pages in the 150-page preamble to the rule. OSHA specifically explained why vaccination as the single most effective way to target all of the ways that the virus threatens workers in the workplace was a necessary measure here, and it further explained why masking and testing would be essential if workers remain unvaccinated in order to ensure that despite their higher risk level of contracting the virus, they couldn't carry it into the workplace and spread it to their coworkers. So I think the suggestion that this wasn't adequately explained is inconsistent with the arguments they're making. And as I understand their tailoring arguments, and this actually touches on the question you asked earlier in the argument, they're really focused on two things, the categories of workers and the particular workplaces. And they haven't suggested that there are other mitigation measures there that OSHA neglected to consider. They're saying those things should have just been carved out altogether. But that is inconsistent with the Secretary's judgment that all unvaccinated workers face a grave danger and that the risk exists anywhere that employees are gathered indoors together. And again, there might be subcategories within those groups that are in graver danger, but I don't think there is any basis on this record to conclude that the agency lacked substantial evidence to draw the lines that it did.
That's helpful, thank you. My second question is, again, about the status of this rule as an ETS. So Chief Judge Sutton pointed out in his dissent from the denial of initial en banc that OSHA did not adopt this rule in response to the emergency, qua emergency, because that had been ongoing since early 2020. But instead, it responded to new facts on the ground, which included the widespread availability of a vaccine that maybe it was a surprise many people chose to forego, and the emergence of the Delta variant. And Chief Judge Sutton pointed out that in an extended pandemic, or I don't know if we've moved to an endemic such as this one, facts will continually change. New variants will emerge. There might be new treatments, new vaccinations. We have boosters now, right? So now full vaccination might not just be the 2 jabs. It might include a booster as well. So when does the emergency end? I mean, a lot of this argument has been about Congress's failure to act. 2 years from now, do we have any reason to think that COVID will be gone or that new variants might not be emerging? And when must OSHA actually resort to its regular authority and go through notice and comment and not simply be kind of doing it in this quick way, which doesn't afford people the voice in the process that they're otherwise entitled to?
So I think if I could respond to that in a few different ways. Congress defined when the emergency exists. It labeled this an emergency temporary standard, but it's dictated by the statutory requirements. So there has to be a grave danger from a physically harmful agent or a new hazard, and the measures have to be necessary to protect against that danger. And we don't think that there's an additional free-floating requirement about emergency status that has to be taken into account.
So it could be an emergency 2 more years from now.
Well, I certainly take the point that the emergency can be of substantial duration. Of course, this is not a way to bypass notice and comment permanently. Congress further specified that the agency is expected to conduct a rulemaking process over 6 months, and that's why the agency estimated the lives saved, the hospitalizations prevented over the 6-month life of the rule.
Sure, but I was envisioning a new rule, right? Like, you know, OSHA might 2 years from now adopt something that's different from this vaccine or mask and test mandate. I'm just talking about the limits more generally on OSHA's power under the ETS provision.
The limits, I think, are the ones written into the statute, and so if you want to project out 2 years from now, I think it's entirely possible, of course, that the trajectory of the pandemic will change. I certainly hope so. And in that case, OSHA, I think, would have to, if it wanted to regulate again, cross the high burden of showing a grave danger. You know, this is an authority it has used sparingly in cases of what we think are true emergencies, and I think to suggest, based on concern about what might happen in the future, that its authority should be constrained or clipped now when we are in the middle of an unprecedented pandemic that is claiming more lives than we've seen in a shorter amount of time would do a disservice to Congress's anticipation that OSHA might need to act quickly in response to dangers like this.
Thank you.
Mr. Keller, rebuttal.
Two points, Mr. Chief Justice. First, we need a stay now before enforcement starts. Our members have to submit publicly their plans to how to comply with this regulatory behemoth on Monday. Vaccines would need to occur by February 9th. You would need 2 vaccines to comply. Those vaccines would have to start immediately. Tracking and record keeping cannot happen overnight. And on tests, you heard my friend, the Solicitor General, mention the media reports that we've all seen about shortages of tests and cost increasing. Our declarations, appendix page 345 and 374, confirm that as well. And that's exactly why workers will quit right away. You don't even have to take our word for it. The federal government, the Postal Service, and Amtrak both say the same things. What OSHA did is they cherry-picked one study about healthcare workers, a very specific industry, and what that worker attrition rate would be. Again, 2 declaration sites. We have plenty more, but appendix pages 351 and 374. And my second point to close on is about who decides in the public interest. And I would submit that this court's precedents answer that. We're not asking this court to reverse anything. Industrial Union 40 years ago, in Justice Stevens's controlling opinion, said that there was an absence of a clear mandate in the OSHA Act. So it's unreasonable to assume that Congress gave OSHA unprecedented power over American industry, and the emergency power is also narrowly circumscribed. Yet here OSHA has never before done mandated vaccines or widespread testing, much less over all industries or on an emergency basis. So whether we're talking about the agency's failure to explain, whether we're talking about the statutory term necessary, whether we're talking about how this has to be tethered to the workplace under the major questions doctrine, under any one of those theories, we are likely to succeed on the merits. And finally, when it comes to the public interest, as this court just recognized a few months ago, it is undisputable that the public has a strong interest in combating the spread of the COVID-19 Delta variant, but our system does not permit agencies to act unlawfully, even in pursuit of desirable ends. We would respectfully request a stay of this unprecedented sweeping ETS before Monday.
Thank you, counsel. The applications are submitted.
Counsel, I have a question about Rooker-Feldman.
Yes.
So I understand, let's say that I agree with you that your no contamination claim is not barred by Rooker-Feldman, because I think you could say the CCA's decision, assume it's an accurate interpretation of state law. It's just as if the no contamination requirement was on the statute, it's in the statute itself, and so it's a different claim. Is that true, though, of the delay finding and the harmless error? Like, jury would have reached the same verdict even if it had known about the exculpatory evidence findings? Because those, it seems to me, am I right that you're raising a procedural due process challenge to that as well, that that's part of the claim?
That's right, Your Honor. So we're challenging the three different aspects.
So why aren't the other two not barred by Rooker-Feldman? Because those seem to me about the application of the state standard to the facts of your case.
Right. So we set out some of course, we're not at the merits yet, but we set out some of the merits theories on pages 40 and 41 of the blue brief. What I would say is it's a challenge actually to the rule that the Court of Criminal Appeals articulated there. So, for example, on what we might call the exculpatory evidence requirement, the problem is we've alleged it, or there's several problems, but that the Court of Criminal Appeals says that the
inculpatory doesn't count?
Discredited, so you can't show that the state's trial evidence has been discredited, which is something I think Justice Sotomayor's separate opinion in 2020 shows this is a problem. You can't point to other evidence inculpating, for example, Jimmy Finnell, and then the unreasonable delay bit it's not about the application, it's not the particular application of the judgment, it's about the rule that you can use against the prisoner, these efforts to establish exculpatory evidence, the types of evidence we were just talking about on the exculpatory prong, and hold them against the prisoner. So.
Thank you. That's very helpful. A quick question on the Article 3 point. Why didn't you seek an injunction? Why did you do declaratory judgment instead?
I think a few points, Your Honor. The first is that it's, of course, not necessary. We pointed in the briefing to Franklin versus Massachusetts. This court can expect executive officials to abide by the court's rulings. And really, I think as far as the court would need to go to find redressability here is to say, if the federal district court were to say, these procedures are unconstitutional, you have to provide due process, you have to have a version of Article 64 that provides due process, even just that would remedy the injury, because again, the injury is deprivation of DNA testing without...
Oh, no, I understand your argument. I was just wondering why you didn't,
I just didn't think it was necessary.
Okay.
So what I'd like to do is perhaps move to the practical considerations and the problems with the Fifth Circuit's rule on Gertz's rule. As I stated in the opening, on the Fifth Circuit's rule, the only injury that the Fifth Circuit seemed to care about occurs when the trial court first denies testing. But I think if that's the rule, then every single time a prisoner continues to pursue relief in state court and seek that testing, there's a great risk of parallel proceedings, because the prisoner is going to have to run to federal court, file a complaint that's protective. The judge may or may not require motions and responses to figure out what he or she is supposed to do with that protective complaint. And then there's going to have to be an amended complaint once the state appellate courts rule on the issue.
Mrs. Barrett?
Mr. Waxman, this is not a question about Harvard's history of anti-Semitism, but I do want to go back to the opinion in Bakke and Justice Powell's holding up Harvard's application process as a model. And then Justice O'Connor and Grutter again referred back to Harvard's admissions process. And I want to know whether Harvard's admissions process has meaningfully changed from the time that Justice Powell held it up. I mean, what Justice Powell found attractive about it, what Justice O'Connor endorsed, was the holistic aspect of it, and that race can be used as a tip. In its essence, is it the same?
Yes, race can be used as a tip, as one of many, many, many tips in an effort to achieve diversity that is across many, many dimensions beyond ethnic.
And so in the way that Harvard thinks about its admissions process, it is the same now as it was in Bakke.
Yes, Harvard is, can I just give one sentence
Sure.
explication to that? What the Harvard Admissions Committee is attempting to do, with the benefit, the luxury of a pool of applicants that is supremely qualified, is to bring together a class of 1,600 matriculants who are best, in the judgment of the admissions committee and the faculty that oversees it, are best able to learn from and teach each other as an organic whole.
So my question is, we've been talking a lot about endpoint, and my question is, so Bakke was, almost 50 years ago now. If Harvard's admissions process is essentially the same in the way that it accounts for race and thinking about endpoints, and I recognize and you describe some of the things that Harvard is doing to try to recruit more minority applicants, but why are we to think that there will be an endpoint? And Grutter's pretty insistent. I mean, Grutter says the requirement that all race-conscious admissions programs have a termination point. So there has to be one, and if it really hasn't changed much since Bakke.
So the system, that is, we're taking race into account as one factor among many, obviously the extent to which race qua race is a factor is dependent on the extent to which so-called race-neutral alternatives have already helped Harvard to matriculate a class that is diverse along this dimension and others. And Harvard does track its progress in this regard and accommodate the admissions process. For example, in terms of where we are, when will we get there? The record contains, any number, a faculty committee study, a working group, a task force, all of which made reports about this, but it also annually does a comprehensive survey of its graduating seniors and asks them questions that go to this. And the survey and the record on the benefit side, I think to Harvard's great satisfaction, showed that 2/3 of all of the seniors said that their Harvard experience strengthened their ability to relate to people of different races, nations, and religions, and 70% said that Harvard's experience had led them to seriously question or rethink their beliefs about a race or ethnic group different than their own.
But that's showing the educational benefits of diversity, right?
And it shows that in terms of, are we there yet? We're not going to achieve 100%. Honestly, 70% is pretty darn good. And it would not have been, at the time that Harvard wrote its brief in the Bakke case and at the time that Grutter was decided, those were not the statistics.
So you think you're getting closer to a termination point?
We are very definitely getting closer to a termination point, both in terms of engineering race-neutral alternatives, but also achieving a class that is diverse across religious, viewpoint, racial, ethnic, academic, political. Yes, we are proud of the progress we made. As Dean Smith said, we still have work to do, including with respect to the way in which we treat students and allow students to interact with each other once they get here.
Okay, thank you. But I guess, in our earlier argument, Justice Kagan pointed out that this gets to be slicing the salami pretty finely. I mean, it's one thing to say, yes, that shows resilience because you've written about overcoming discrimination. And a student could write about any number of obstacles that they've overcome, from physical disabilities on down the line. But what if, Justice Jackson had asked in the last argument, about pride? What if an applicant wrote an essay about how integral their racial identity was to them as a source of pride, and the cultural attributes of the racial heritage were very important? Would that be okay, even if it were all intimately tied up, say, with the traditions of a Mexican family? And if the answer is no, that can't be extricated from race, why would that be different than someone writing about how important it was to them to have this passion for music in their life, that they loved music?
I think culture, tradition, heritage are all not off limits for students to talk about and for universities to consider. They can't consider that. They can't read that and say, oh, this person is Hispanic or Black or Asian, and therefore I'm going to credit that. They need to credit something unique and individual in what they actually wrote, not race itself.
Justice Barrett?
Let me pick up on the vacatur point. So one question I have, obviously the Chief and Justice Kavanaugh have pointed out that the courts of appeals, particularly the DC Circuit, have employed the remedy of vacatur for a long time. Why isn't it possible, and let's say that I agree with you and agree with some of the scholarship that says that this was not contemplated at the time of the APA's enactment. Why can't remedial authority evolve over time? Even if injunctions and declaratory judgments are what those who enacted the APA, if Congress had in time, scholars at the time, Jaffe, thought that vacatur didn't occur to them. Remedial authority is a flexible concept, and so maybe the courts of appeals have expanded that concept. Why would that be impermissible?
Well, I think it would be inconsistent with how the court ordinarily approaches these types of questions of statutory interpretation. And I think if you agreed with us that this is not what Congress meant to authorize when it enacted Section 706 of the APA, then there would be kind of no basis to alter the text at this date and to suggest that actually the court can read into that language that all agree was not intended to cover vacatur.
But set aside as broad, right? It's not specific. And even in 703, it says including actions for declaratory judgments or writs of, prohibitory or mandatory injunctions. It doesn't exclude it. And given that set aside is broad, you're asking for a narrowing construction of it. And I guess what I'm saying is when set aside could be read to include vacatur, it doesn't preclude it. Why is it not subject to evolution?
Well, I think that there's an additional problem here with trying to expand it in that basis insofar as it would expand beyond party-specific relief, and that implicates its own considerations under Article 3 and implicates the same arguments we've been making about nationwide injunctions, that when courts issue remedies that go beyond the parties in the case, it can take courts beyond the traditional forms of relief that are authorized, whether under Article 3 or under the statute. So I think here, reading into the statute a new unprecedented remedy that would apply on the agency action itself instead of with respect to the parties would be problematic.
Okay, I'm glad you brought that up because I have a question about that too. Why don't you treat this then as a jurisdictional argument? You concede that vacatur could be appropriate in a special statutory scheme, but say simply that as a matter of statutory interpretation, that APA doesn't authorize it. Why isn't it a matter of Article 3 jurisdiction? Why do you concede that it would be acceptable if Congress specifically authorizes it?
Well, as this court well knows from its various cases, trying to parse that line on whether specific statutes are jurisdictional or not, it can often require Congress to speak very clearly if it's trying to attach that jurisdictional label. And here, with respect to the remedies that the APA contemplates, we don't...
No, I mean as a matter of Article 3.
As a matter of Article 3 jurisdiction, I guess it would be possible to think about it that way. We haven't made that argument, but I wouldn't want to shut the door on it because of the particular concerns with extending beyond party-specific relief.
Last question on jurisdiction. In response to some of Justice Gorsuch's questions about whether we should interpret 1252 to be a preclusion of remedial authority or actually tied into jurisdiction, you said you thought it was jurisdictional. If you think that the APA doesn't authorize the remedy of vacatur, is that jurisdictional? By that same logic, I mean.
So no, because I think if the APA doesn't authorize vacatur in the first place, then you wouldn't have any issue under Section 1252F1. So we're not disputing that a set-aside order in the terms of just setting an unlawful agency action to the side for purposes of rendering...
No, maybe I didn't articulate my question well. I understand that 1252 precludes jurisdiction.
Yes.
I'm saying that if a court lacks jurisdiction when it lacks the authority to issue a particular remedy, why wouldn't we understand the APA then? Why wouldn't we understand this issue as a matter of statutory interpretation to be jurisdictional? Because if the district court is entertaining an action to award a particular kind of relief that it lacks authority to award, would that be jurisdictional?
We have not previously argued that this APA limit is jurisdictional. The reason we've made the arguments under 1252 is because it specifically says no court shall have jurisdiction to do this, and we think that that is Congress clearly acting to attach jurisdictional consequences to an exercise of remedial authority. But I take the point, and I think it might be possible to conceive of a jurisdictional basis as well if a statute is actually preventing a remedy from being ordered.
Okay, last question. This one goes to the merits. So Justice Alito was asking you, you were kind of going back and forth with him about the complexities of making the determination whether a non-citizen even falls in one of these categories in the first place. And I just wanted to give you a chance to address how, there's a portion of the statute that talks about your, it's in CD, the Attorney General shall devise and implement a system to make available daily on a 24-hour basis to state, federal, and local authorities to determine whether individuals arrested for such authorities for aggravated felonies or aliens, and then it goes on. Why isn't that where the discretion and the resources should be channeled as a matter of statute rather than into the holistic inquiry that the memorandum dictates?
So I certainly acknowledge the point that Congress might have anticipated that it would be easier to make this determination about aggravated felony status, and it set up mechanisms to try to ensure that there was information sharing between the federal government and the states. And I think maybe Congress couldn't have anticipated the developments in this court with respect to the categorical approach and the legal complexities that would raise about trying to monitor any number of varied state statutes that can be drafted in very different ways, with the end result being that before it's possible to determine determine with certainty that someone is subject to 1226C2, it often involves an investment, a considerable investment of resources and consultation between officers and legal advisors to try to ascertain the scope of that provision.
But you do have such a system?
Yes, we do have systems to share information between states and the federal government with respect to those who have criminal convictions in state court.
Thank you. So clearly erroneous?
Yes.
To agree with you, we have to find, because you didn't talk a lot about the clearly erroneous standard in your brief, so I wondered whether you were saying that the district court's factual findings were clearly erroneous, or that the district court made an error of law because it didn't offset burdens with benefits.
No, we are arguing that these factual findings are clearly erroneous, and I recognize that the court infrequently delves into facts like these, but I guess what I would say is that if any facts are clearly erroneous, it's these facts, and it's not hard to see on the record why. The district court committed really two independent errors here. The first thing is that it looked at the wrong time frame. It focused on fiscal year 2021 to suggest that the states had incurred costs, but that was a time period before these guidelines even took effect, and so it was improper to draw those kinds of causal errors based on that data. But even putting that to the side and looking at the data, it doesn't support the district court's analysis. The court said DHS is not detaining the same number of criminal non-citizens, but the very chart that the district court included at JA 314 shows that over the time in question, the number of criminal non-citizens in custody remained essentially unchanged. And then with respect to removals, the district court said DHS has done far less enforcement action with removals and focused on a comparison between fiscal year 2019, about 250,000 removals, and fiscal year 2021, where there were about 55,000. But the district court ignored entirely that that was during the pandemic, and the CDC's public health order under Title 42 was in effect, and DHS excluded more than 1 million non-citizens under the Title 42 order. So the bottom line conclusion here that there was less immigration enforcement overall, I think, was clear error.
Justice Barrett?
How can you disagree with that in light of the stipulations that Justice Gorsuch reviewed with you? Because if it's speech, you know, as the stipulations Justice Gorsuch read did, and she has to say it, why isn't it compelled speech?
Because on the stipulations and where we are here, the company would refuse to provide the same identical speech to a customer solely because of who they are. And if the company is going to provide speech, already said they're going to do it. The website, I think it was the colloquy with Your Honor, Justice Barrett, where someone comes in and says, I want the exact same website as you gave to my friends. And the company says, no, I will not provide that to you. And the only reason is because of who you are. That's not compelled speech. Certainly there are some circumstances where there may be more of this, you know, tell the story, et cetera, but the company can choose to determine the services that it wants. Here it is chosen to say that I will not provide the exact same website for one couple that I would for another solely based on the identity of the couple.
Okay, I want to give you a hypothetical that doesn't rely on disagreement, philosophical or otherwise, with speech, but just a desire to promote a different kind of speech. So let's say a newspaper is running, as many newspapers do, runs marriage announcements. And so, you know, the New York Times says that such announcements, which it picks, have to satisfy its normal editorial standards. Let's just say that the newspaper for Gay Pride Month decides that it's going to run to promote and recognize same-sex marriage, only same-sex marriage announcements. Turns away heterosexual announcements, not because it disparages or disagrees with opposite-sex unions, but because it's trying to promote something else. Can it do that? That's a protected characteristic under the law.
Well, that's a hard hypothetical because normally the marriage announcements are considered to be a public accommodation, but your hypothetical introduces a layer of editorial discretion.
Well, you can't run every marriage announcement that comes. There would be too many. So you're necessarily going to pick and choose, just like every business is going to have to pick and choose based on resources.
Well, and I think, but in that circumstances, if the sole basis for picking and choosing is a protected characteristic, the New York Times couldn't say that we're going to have this month, we're just going to run opposite-sex weddings. Next month, we're just going to run white people weddings. Next month, we're just going to run.
So for Gay Pride Month, a newspaper can't choose to try to celebrate that and communicate a message by running only gay marriage announcements?
Well, again, I think the answer is no, but that's an unusual case because a newspaper obviously typically has great discretion.
Well, it might be an unusual case, but the problem, and what a lot of the hypotheticals are getting at, is however we decide this case obviously applies to others. And what if we say it's not the New York Times, but what if we say that it's a gay rights group that wants to publish gay rights announcements online all year round, not just for Gay Pride Month, because it wants to celebrate love in that community. And so it publishes only same-sex marriage announcements and turns away opposite sex. Can the gay rights organization do that?
Well, I think that's very unlikely to be a public accommodation, so the answer is likely yes.
Well, they're paid. Why? I mean, they're paid. I mean, they craft these for, and it's a business, it's a commercial enterprise, but they craft these announcements for the gay community.
So I guess who crafts the announcement? I thought
It's a gay rights enterprise. It's a group run by people who are interested in promoting gay rights, and it's a forum to celebrate gay marriage. They charge, you make money, and you run marriage announcements that have our story, etc. But it's done specifically to celebrate love in that community. Can they turn away opposite sex marriage announcements?
In this unusual hypothetical, assuming they're public accommodation, they cannot turn away announcements based on a protected characteristic. So they couldn't turn away opposite-sex announcements or interracial marriages. I think if they're a public accommodation, but I think
so they can be compelled to. It's not that they have anything against opposite-sex unions, but they can be compelled to give their web space to those announcements, even though it's not consistent with the message of their organization.
Again, assuming they were a public accommodation and opening themselves to the public,
assuming they're
yes,
public accommodation.
They can do that. But I think what makes the hypothetical difficult is that assumption likely does not apply to most organizations like that.
It seems like you can't get out of everything by defining public accommodation narrowly or broadly, depending on it. I mean, you agree that in Hurley, the parade was a public accommodation, as we held? Because Hurley is your hardest case, right?
It's a difficult case, but we are different than Hurley, and I'm happy to talk about why. But the public accommodation law was applied to the parade in Hurley, and the court said that was, because of the peculiar circumstances there, it was inappropriate. But importantly, in Hurley, everyone could march in the parade. The only issue was who could carry the banner in the parade, and in this case, people can't march in the parade. The company is turning away people for their products based solely on who they are, and that's the big difference from here in Hurley.
Thank you. What if the law schools also had to make available their CDO to sit down with the military and help them craft, a statement that would be attributable to the military? This is why a career with the military, this is what it would be, this is why it's attractive, and then post it. Would that change Rumsfeld?
So there was actually evidence that those sorts of services were offered that the law schools were pressing that are referenced in the Third Circuit's opinion, but not specifically referenced in this court's cases. I think what that starts to get into is how do you draw the line between are you providing, is it really the same speech that you would provide for someone else, and are you being required to do something that goes beyond that to express the sort of opinion-related statements that Justice Kagan.
What if they do it for everyone? The Career Development Office will do that for, law firms. This is the job of an associate, and here's why it would appealing, what you'd be getting out of it. If they do that, then they would have had to do that for the military, or would that make that case more like Hurley?
So I guess here's the way I'd answer the question is the way that Hurley did. We read Hurley to ask, is the compulsion, is the burden on speech, is it truly incidental to the content-neutral regulation of conduct? And what Hurley started with on pages 572 to 573 is being emphatic in saying this parade is not excluding people because they are gay and lesbian, it is excluding them solely because of the message that they want to send. And so the court said applying the public accommodations law to them is not incidental. It's not serving the content-neutral regulation of conduct because they're not discriminating on the basis of status. Instead, the law in Hurley, the court said, was equivalent to a law saying that the parade had to include any message that any protected group wanted to offer. That is not an incidental burden on speech. That is a direct burden on speech. And the reason why we view this case as being like Fair and not like Hurley is because Colorado is not asking Ms. Smith to say messages or to speak messages that she would not speak for anybody. The only thing that it is saying is you can't discriminate based on status, and you can't define your services based on protected status, so that you can't say the message that I object to, that I won't speak for anybody, is a message that is tied to the customer's status.
Mr. Fletcher, what if you have a gay couple who runs a web design business in a college town? And a big part of their business is developing websites for student organizations, the environmental organization, like different rec club leagues, whatever. And then you have a Christian organization or Catholic organization that basically stands for and advocates traditional views of marriage. This is the raison d'etre for the club. They host debates, invite speakers, and they want the standard website that this couple provides in their business, which is, graphics that make it look appealing, kind of an About Us page that describes what they do and what their beliefs are. And let's say that this couple, like 303 Creative, has on the bottom of every page, like, designed by, Jack and Michael. Everything this club wants to say is an anathema to this couple. Do they have to, can you compel that speech? Do they have to publish it?
I don't think they do.
Why?
Because I don't think that's a refusal based on status.
Okay, this is my question. That's why I asked it. Because I think here there's a difference of opinion about whether turning down the same-sex couple simply for purposes of the marriage announcement is a turn down based on status or message. And it seems to me in my hypothetical that the status of the club is inextricably intertwined with the message they want to speak. So why is it different?
For a couple of reasons. I think, first of all, just to start with the same-sex marriage context, this court has recognized that that's a circumstance where status and conduct are inextricably intertwined. In Lawrence and Masterpiece, the court has said refusing to serve for same-sex marriages is discrimination against gays and lesbians because status and conduct is inextricably intertwined. The public accommodations laws and the anti-discrimination laws generally don't work that way in general. We don't think that the expression of particular views is inextricably intertwined with having a particular religion or being a Democrat or a Republican. In general, in public accommodations laws, we say when you discriminate against someone because they want you to print a website or serve an event or cater an event for something that you disagree with, we wouldn't say that that's a status-based refusal. And I think that's correct. I don't think...
So this is a carve-out that's applicable just to the same-sex context?
I think it's a context. It's like the court's recognition in Bray that a tax on yarmulkes is a tax on Jews. There are certain rare contexts where status and conduct are inextricably intertwined, and I think the court has rightly recognized that same-sex marriage is one of them.
Thank you.
Thank you. Justice Barrett?
So could you, I'm going to follow up on Justice Kavanaugh's question about Chief Justice Rehnquist's concurrence in Bush versus Gore. So I understand that that's not this case because that was an interpretation of a statute and we're talking about a state constitution. But I take it that if we were talking about an interpretation of a statute, you would agree with Chief Justice Rehnquist's approach?
Yes, we do agree.
And on the theory that at that point the state court would not be acting as a court but would be acting more as a legislature?
That's right, Your Honor. I do want to point out that if the court were to rule in our favor in this case, it would not necessarily follow that it would have to rule the same way as the Bush versus Gore concurrence for this reason. Statutes are always less problematic under the Elections Clause because they can be repealed. They can be rewritten by the state legislature. So by definition, a statutory and impermissible distortion of a statute, it can be remedied by the state legislature. Now, it couldn't in Bush versus Gore, there wasn't enough time, but the point is, and we think the concurrence was correct, but I just wanted to make the point that it does not necessarily follow that if the court rules in our favor in this case, that case would come out the way the concurrence did in Bush versus Gore.
Well, I have a question that follows up on that, but before I move to that, I just want to ask you quickly. So if we're asking about novelty, if we're asking about an egregious departure, or if we're asking about the distinction between substance and procedure, those are kind of all notoriously difficult lines to draw. But in your colloquy with Justice Sotomayor, you were talking about the lack of judicially manageable standards for, say, free and fair elections. Why do you think that that's less judicially manageable than, say, deciding whether something is substance versus procedure or an egregious departure, truly novel?
Well, just to be clear, Your Honor, so in terms of figuring out whether there's been an impermissible distortion of a statute, that's where you have to look to see whether it's novel.
Right, but I thought you said you agreed with that approach.
I do. I'm just saying that in this case, none of that is implicated.
I understand that.
Yeah. Okay. And so I apologize.
Well, I guess I think substance substance and procedure, as many of the questions that you've gotten indicate, are difficult to separate out. And so I'm saying you're leaning pretty hard on the lack of judicially manageable standards for things like free and fair elections. So I'm saying, why should we take solace in a substance procedure definition as a more manageable line?
Well, thank you, Your Honor. And I would point to the court's decision from 1946, Murphy, where it is talking about the Rules Enabling Act, and it's setting up the line between substance and procedure.
Which is, as a former civil procedure teacher, I can tell you, is a hard line to draw and a hard line to teach students in that context as well.
Well, and the court could take a functionalist or a formalistic approach, but we're saying take a formalistic approach. Say that if it is a hoop that needs to be jumped through, then it is procedural. And if it's an effort to limit the content, and this is an easy case, that this is obviously substantive because there was a map and it was thrown in the trash by the courts. And so this isn't even close to the line, but we think my friends on the other side, they're trying to adopt and asking the court to adopt a functionalist approach. They say on page 57 of the state respondent's brief that yes, there's something to this idea that that there are limits on the extent to which the state constitution can control the state legislature. The state legislature has to have, quote, a central role, close quote. That is a functionalist test if ever there was one. And how do you define the center, and how far from the center can you go? And oh, by the way, if this is in the center, then the center is pretty much coterminous with the circumference, because we've been sidelined. Completely.
I'm sorry to cut you off. I just don't want to take too much of my time. I just want to ask one last question. You were pointing out that state constitutions entrench norms, and so they're more problematic than statutes.
Yes.
But a lot of state constitutions can be amended by simple majorities in, say, the referendum process. And so, we know from Hildebrand that if a districting is done by referendum, that's okay. That doesn't violate the election clause. So why is it any different, say, if a state constitution is amended and some substantive provision is added by referendum, but it would be problematic? Why is that problematic? When it can be changed by a simple majority, why is that more entrenchment? And why would we say that having it appear in the Constitution is problematic when, if it appeared through the referendum process and the legislative process, it's not?
Well, respectfully, Your Honor, if we're trying to get at the original public meaning of the Constitution, I think everyone agreed in Arizona that these referendum were unknown at the time of the founding. And so James Madison was...
But you're stuck with Hildebrand. I thought you weren't trying to get rid of it.
I'm not trying to get rid of it, but if we're trying to say why would the founders have objected and been worried about partisan gerrymanders in a state constitution, they would have been worried about it because it was maximally entrenching. If the question is why would they have drawn the line the way they drew the line, that I'm saying they drew the line, is because Madison was worried about entrenchment in the state constitution. And some states may have this procedure, others don't. But typically, if you want to try to solidify something to the maximum extent possible politically, you typically put it in to a constitution.